topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Experts show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Good afternoon, Orlando. Welcome to another Ask the Experts, where we bring you the top experts in the field of legal, health, financial, and home improvement. Hey, today, if you live in a condo or an HOA, an association, we have the greatest show. We've got the top law firm in the state of Florida, K. Bender Rimbaum. And we have an attorney, Alan Swartzide, with us today. And we're going to be taking your questions, whether you have it for a condo or it's an HOA question. This is the time to get free advice. You can call in today at 561-623-9429. If you're watching us on TV, we're scrolling that number throughout the show. Again, 561-623-9429. Or we have a chat line set up that will take your questions. Let me introduce you to my buddy, my pal, who just was on with us the other day in Tampa, attorney Alan Swartzide.
Steve, how you doing?
Doing well. You ready for another big show?
Let's do it, my man. I'm ready.
Okay. So first of all, especially with Orlando, we are getting so many people, new people, who've just found the show. Tell people about K. Bender Rimbaum.
Sure. Well, we're a firm of 20 attorneys. We have offices in Orlando, which is my office right near UCF, Tampa as well, Pompano Beach, and Palm Beach Gardens, and Miami by appointment. Literally all our firm does, except for maybe a task here and there, is the way I would put it, is represent community associations. It's all we've done since the 1990s. And, we stay in our lane. We know where we belong. We don't try and be real estate attorneys. We don't try and masquerade as something else. We don't allow anyone else to come in and masquerade as community association attorneys. This is a highly specialized area of law. So my perspective has always been, if I'm going to work in a specialized area of law, I need to make sure that I focus on it. And we do have 8 attorneys within the firm that are board certified specialists in this area of law. Another one that does construction and is board certified in that area. So rather than belabor the point, I will say that, I think we have a great firm here. We're extremely communicative, and, shows like this, educational programs are really, I think, what sets us apart, but also that level of communication where you're going to hear back from us within one business day, which I posted on LinkedIn the other day, how shocked I am every time I hear, well, we wrote to our attorney and it's been 3 weeks and we haven't heard back from them. What do you think we should do? And my answer is, you should be working with me instead. But, the bottom line is, I think that there are a lot of really good attorneys out there. Hopefully the one that you're working with is willing to give you the guidance that we're providing for free today and in all of our classes. And we'll talk about those classes later on. But Steve, I appreciate the opportunity to explain a little bit of what the firm's all about. But really, if you are a community association that needs help with a legal issue, that's what we do.
Well, hey, listen, the other day we left about 3 or 4 people on the phone. We had people in the chat room. Let's get to it. Maybe we'll get to everybody's question. Let's go to Karen first. She wants to know, is there anything in 718 that says you should have evacuation rules and condo rules and regulations?
Well, I mean, there's nothing that says you should have those, but I think you should anyway. I mean, the bottom line is you want to have an emergency plan in place at a condo, regardless of where in Florida you're located. You know, it used to be a joke, but the reality is if you live in Florida, you're in a flood zone. Doesn't matter where in Florida. This all used to be swampland. So the bottom line is my suggestion, yes, absolutely. Have not only an evacuation plan, but a plan for what you're going to do to try and keep the community safe for those that can't evacuate as well, or that want to eventually come back to the community. So I'm not aware of anything in Chapter 718, which for those that don't know is the condo statute, but that doesn't mean that you shouldn't have it anyway. I think for anything that you can do to put policies, procedures, and plans into place before a problem pops up is going to be beneficial for your community, unless your plan sucks.
You know what, Alan? I think maybe Karen read one of the same articles I read, that they're saying that this year that South Florida is going to have the worst year for hurricanes. They're predicting something like 13 major hurricanes. So it was a very big article, and it also gave the reason why this year is going to be the worst hurricane season ever for South Florida. So I'm sure that had maybe something to do with Karen's question.
Well, I knew what to expect. 5-6 years ago, I moved to Central Florida instead of staying in South Florida. I knew this was coming.
Yeah. Central Florida gets hit a lot nowadays.
We do, but I think I'm safer than when I was in South Florida, although I certainly have concerns for my family and, frankly, also my coworkers and colleagues down there. But yes, I mean, you should be concerned, but again, put a plan in place, make sure you've got hurricane shutters on your building, and pray for the best is really all you can do at that point, as long as you've done what you can in advance.
Exactly. Let's go to Cindy in Altamont Springs.
Okay.
She wants to know, is there any HOA laws regarding security cameras?
So there are laws regarding security cameras. None of them are specific to HOAs or condos, but there are laws that were passed recently or that are in the process of being passed. I honestly don't recall which, but pertaining to the security of your building in general regarding negligence, I think it passed last year, where if you have certain security cameras and they're actually operated properly and you have lighting and you have certain other things, basically safety features, there's a presumption that arises that the association wasn't negligent if someone gets hurt on association property. So that's one law that exists regarding security cameras. The other are just privacy laws in general. You want to make sure that if you are using those security cameras, they're not directly pointed at anyone's property, because that could be an invasion of privacy. So there's nothing in Chapter 720, the HOA laws in particular, and that one I can say with certainty, but there are laws that govern this, and there's case law also that governs the invasion of privacy and the negligence concerns and all of that. So I would suggest you get with your attorney and see if the newish security law that I believe took effect in July of last year is something that you can take advantage of by implementing those security measures, including the cameras.
Alan, you and I talked about this the other day, and because we are inundated, people writing in about they're hearing about the possibility of these new laws. And I think you called it right that they haven't been signed by the governor yet, so it's a little premature to get involved with them, but it looks like there are new laws coming out soon.
Yeah, absolutely. And I know for a fact, my partner, Jeff Rembaum, I think already put out one of his roundup emails about some of the things that are on the table as potential new legislation coming up in the next few months. But we'll have a legislative update webinar and seminar coming up as soon as we find out. And I think we might actually have one coming up near in the next few weeks. That basically goes through what's going on right now. Actually, yes, Mike Bender's going to be teaching one with Jeff Rembaum, two of my partners, with Castle Group. That'll be on April 17th. So we do have that coming up before, Steve, yours and my next show. But the bottom line is, I do think it'd be premature to sit and discuss because, frankly, I'd rather get to people's questions that are about current law rather than speculate as to what the governor is going to approve, ignore, or veto.
Well, I totally agree with you. I just didn't want people to think that, that we're not addressing that. It's just a little too early, and we have plenty of time to find out what the new laws will be once the governor signs them.
Right, and keep in mind, I know we mentioned on Tuesday that most of those will take effect in July, if at all. So you're going to have plenty of time, especially if you want to go on our website at www.kbrlegal.com and go to the calendar and sign up for Mike and Jeff's class. That's going to give you the information you need far in advance of when those laws kick in. But I'd be shocked, Steve, if we didn't end up discussing them here on the show as well.
We're going to go to John in Orlando. I currently own an apartment in Palm Beach County. I bought it for $290,000 in 2022 with a 3.5% interest rate and 20% down. Apparently, the HOA will shoot to cover, I guess, $1,000 per month, but they're going from $600 to $1,000. And there is speculation there will also be an assessment between $30,000 and $50,000 per unit. Should I sell or go through and keep it?
I mean, that's 100% a business decision. This is clearly an investment property based on the question that was asked. I don't see you getting a better interest rate. So unless you're planning on doing something else with your money, or that $1,000 a month, the additional $400 plus the special assessment that the board is considering, unless that's going to be prohibitive where you really can't justify keeping the property, I don't see it as a reason to necessarily back out. The other thing that to keep in mind is it depends what that money's being used for. If it's to beautify the community, then that 200 something that you paid, that might skyrocket up over the next few months or years as they do more work towards the common areas. And I think you said an apartment, I'm guessing that means a condo, so common elements. If they're using that money to clean up and beautify the community, your unit might be worth more as a result of the dollars that you're paying out. Because keep in mind, all these assessments, all they're going towards is maintaining the community. And some of it might be reserves and things like that you weren't required to maintain before. We've talked about that pretty much ad nauseum, Steve. Those new reserve study requirements and milestone inspections and the new reserves you need to get. They might be related to insurance costs as well, which you're not going to avoid by owning property in some other area of Florida. So really, it's a business decision, but I would take a look more closely at what that budget allows for. What's the money going towards? If it's to beautify the community and make sure that it's properly maintained and operated, your property value is probably going to increase. Whether that's enough to justify keeping the property at such a low mortgage rate, that's totally up to you.
Okay, well, we get our chat line is going wild. Let's go to Jim. Our HOA assessment invoice lists 3 items: dues, maintenance fees, and capital reserves. The financial statements have one line: income. Is a little hard to read. It's commingling. Yes. Operating funds and reserve funds allowed or recommended.
So generally, probably not, but you're in an HOA. And I have seen in many HOAs where they qualify something in the budget as a reserve, but it's never been established as one. This is just something they're calling a reserve so that they have money put away when an asset fails, because that's all a reserve is. We have an asset that we're making sure we have the money to fix or replace when it dies. Okay, so if you're in an HOA, there's only 3 ways to establish reserves. That's by the developer, your declaration, or the members actually voting on it. If none of those 3 things have happened, you don't have a reserve. You have a budget line item, and it's just part of your operating. If that's the case, there's no issue of commingling because that reserve doesn't actually exist. If you've got an established reserve, you can still commingle the funds. You just need to track them separately. And you need to know when those funds are being used, what portion was the reserve, which can't be used for another purpose without a member vote, versus which portion was just operating, which can be used for anything that's in the budget. So I hope that helps. There's a distinction between how to maintain the funds and how to spend them is really what I'm saying. But you probably don't actually have a reserve in an HOA. Sometimes you do, sometimes you don't, but only condos require reserves for statutorily.
Let's go back to our text. Keith in Winter Park. As secretary of an HOA, if I am unable to attend a special meeting called by the president, can I appoint someone to attend in my place?
What was the attendance at? What kind of meeting? I'm sorry, I missed that part because I
Just
cut out my
special
internet connection.
meeting.
It's not great. Special meeting
called by the president.
You can have someone attend in your place by a proxy, but you can't have someone else vote as a board member or in your place. You would only be able to have that happen as a member of the community if it's a member vote that's happened. So the shorter answer is, if it's a member meeting, the answer is yes, but only as provided in the bylaws. If it's a board meeting, you can't have someone substitute in for you as a director. That'd be like the governor saying, well, Alan Schwartzide seems like a good guy. Let me have him veto these laws instead of me doing it. You're an elected official of the association, so you can't just have someone jump in for you for a day.
Okay, let's go back to our chat lines. I have a question on how much is the cost to amend the condo docs, and is the board who decides on changes?
So that's going to depend on the documents themselves as to who decides on the changes. Most of the time, the members do get to vote on that, not just the board. But there are governing documents. I dealt with a set literally today where it specifically said the board gets to decide these issues. The members don't have a vote. The members just get notice of it. Now, the cost to amend the documents really depends on what you want to amend. If it's a fairly straightforward amendment, usually going to be a couple hours of attorney's fees. But if you're going to ask your attorney, hey, our documents are 50 years old, we want them updated, that's a much more involved process than just, we want to change this one provision. So that's it's going to cost significantly more. If you have a specific question, if you're on the board and you're not sure whether you should be trying to amend your documents, please feel free to reach out to me and I can give you a quote depending on what you're trying to accomplish. But generally speaking, I usually quote 2 to 3 hours to just draft the amendments and the required accompanying documentation. If it's just a simple 1 or 2 amendments and it's not really involved. But if it's, hey, we want you to take a look at our articles of incorporation, our bylaws, our rules and regulations, our declaration, just reviewing all of that could be a couple $1,000 and usually is, depending on the length of the documents and frankly, whether they're legible or not. That's part of why the first thing I do when a new client comes to work with our Orlando office is pull a copy of the governing documents, OCR them, compile them together in one document so that we can tell, do we actually have something we can rely on and is it legible? And if not, then we immediately try to do what we can to help the board fix that problem. But the short answer is I'd have to see what you're trying to amend in order to give any kind of actual quote of dollar figures.
Alan, we're going to go to our first break. Give everybody the phone number and the website address.
All right. Our number where you can reach literally anyone in all 5 of our offices, 954-928-0680. Again, that's 954-928-0680. Our website, like I mentioned earlier, www.kbr, as in K-Bender Rembam, legal.com. And my email address, just if you want to reach out to me directly, very simple, as@kbrlegal.com.
Beautiful. We're going to go to our first break. When we come back, we're going to go over your schedule for your classes for next month. We'll be right back.
All right. Thank you.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. I'm here with attorney Alan Swartzide, K. Bender Rembaum Law Firm. They're a community association law firm. We're talking about HOA and condo associations today. You've got many ways to contact the show. You can contact us right here on our chat line, which we've got plenty of. And Alan, let's talk about all the different classes you've got this month and next.
Well, I mean, like I said, we consider education pretty important. So this might take up the entire rest of the show, but I'll do what I can. So on April 3rd, we will be at the Broward County Condo and HOA Expo. I know we're teaching collections at that expo. We have April 4th, Kirsten Henza will be teaching a class about updating your governing documents and why that's important. That's via Zoom on the 4th. The 9th, we have the CAI West Coast Chapter Trade Show. I'm on the committee for the trade show in Central Florida, and man, that was a great event. So I anticipate this one's going to be fun too. Hope that everyone enjoys that if you're attending. We have, and I know Kirsten Henza is going to be at that one too. I have a class on covenant enforcement with Castle Group on the 11th. I missed one, Palm Beach County Expo, the condo and HOA on the 10th. That one, we're going to be teaching the importance of updating your governing documents in person. And I believe at all of all of these expos, we'll be teaching a legal update as well. Those are the changes in the statutes that we mentioned earlier. So I mentioned my class on the 11th. I have another one coming up on the 12th, which is milestone inspections and structural integrity reserve studies. We might have discussed those issues on the call once or twice before. Guest restrictions and screening tenants and new owners is going to be taught on April 16th by Kirsten Henza as well. I mentioned the association leadership class with Castle Group on the 17th, which is Mike Bender and Jeff Rembaum. I have an HOA board certification with Century Management on the 26th, and then another one for condos on the 30th. And I'd be surprised if we don't end up with something else in the middle. We also have live events on April 12th at Drive Shack in West Palm Beach, April 24th at Galuppi's, April 30th at Capriccio's. These are all in South Florida. And then all of our appearances on your show as well, Steve. So I hope that didn't take too long. I tried to kind of breeze through it, but that's what we have as of now. I'd be surprised if we don't add one or two more. And I know I'm also teaching a couple classes privately for people. And I'd be surprised, again, if you reach out and you go on our calendar, you don't find something new within the next week. Whew,
and your classes are free.
Yes, all these classes that I mentioned, other than the ones at the Condo and HOA Expo and the last three that I mentioned, those are all free. They're all via Zoom. The other ones are free. I don't know if access to the Condo and HOA Expo is free in and of itself, But if you register, you'll get in. That's pretty much all I can tell you about those.
Beautiful. I love this next chat. You guys are great. Only pay when you use. My neighbor association. Friends tell me you don't insist on retainers, only like many others. That's a nice
That is
compliment.
accurate. Thank you, Dixon. Basically, we ask you to allow us to get your governing documents up front, but that's the only upfront cost of working with our firm, unless you choose to use the collection retainer program, which is just a once per year minimal fee that allows us to basically take on all the attorney's fees and costs that the association incurs in collection. Rather than you paying month to month, you pay it off only if we don't collect from the owner. So yeah, I do think that's different. I know that a lot of firms will tell you they need an upfront retainer of $5,000 to $10,000 to work with a community association. And our perspective is, okay, well, if you want to work with us, we're planning on this being a long-term engagement, and we don't want to hold 5-10 grand of your money for the next 20 years while you continue working with us. I get all the emails about communities that we no longer represent. They are very few and far between. It's kind of like the attorneys that work with this firm who never leave. Our clients don't really like to leave us either. So yeah, we don't require any monthly minimums, no down payment, so to speak, no retainer fees, no annual fees except the collection retainer program. It's just, you need us, we're here.
For those of you who'd like to call in and ask Alan a question, the number here is 561-623-9429. That's 561-623-9429. We do have a line open. Let's go back to our text. Here's Sherry in Orlando. She wants to know, can I sue my HOA or condominium association for negligence?
I mean, yes,
We don't know.
I can sue you can sue anyone for any reason. It doesn't mean you've got a valid claim. It depends whether they were truly negligent or not, whether or not you win, and whether you can prove it. Just like any other lawsuit, you can file that lawsuit. There is a claim for negligence against a community association. It's just a matter of, whether you can prove the elements of a negligence claim. So, the short answer is, yeah, you can. Whether you'll win and whether you'll recover anything depends on the circumstances of your particular dispute. Now, let me just briefly, Steve, go back to my lack of clarity a minute ago. And of course, Jeff Solomon, our friend, is watching and texted me to say that, yes, the expos are free to attend. So the Broward one that's coming up, the Palm Beach one that's coming up, and in May, the one for our area in Orlando, those are all free to attend for members of the public. They're not free for people like us, or more importantly, like me, but they are free for the public. The board members can show up and they don't have to pay, from my understanding. So thank you to Jeff for that tip.
He is so on the ball. Thank you, Jeff. This next chat, we get so many emails. I just don't even get a chance to get to them all. Basically, I think pretty much the same thought. This is from Colleen. She said, when we bought, we were told the condo association maintained the property as written in our docs. Now, she stopped there. I guess she's saying that they're not maintaining it. What can we do? Because we do get a lot of letters like that.
Yeah, I mean, if it's not being maintained properly, item number one, get yourself on the board and figure out a way to convince the rest of the directors that they should be complying with their obligations under the declaration, and the association should be complying with its obligations under the declaration. If you're not able or not willing to get on the board, then you send a demand that the association start maintaining the property in the manner that it's supposed to. But when you send that demand, be very specific as to, here are the problems that I have. Here's why I think you should be doing it differently, or in my perspective, better, etc. Because if all you say is, you guys need to maintain this community better, the response is going to be, thanks for your letter, and it goes in the circular filing cabinet. But if you give a specific, hey, you guys are obligated to cut the hedges to this height and you're not doing it, and here's a picture of the hedge on this side of the building, the east side of the building, and it's clearly 8 feet tall when it's supposed to be 3, that's a little bit clearer as to what you're actually complaining about and what you want the association to do. Just like when you get a demand from the association, if you violate the covenants and the rules and regulations, you'd want them to say, you're in violation of this rule, here's what you did wrong, and here's what we want you to do to fix it. You got to give them the same kind of information to have any reasonable expectation that the association is going to know what you're asking them to do and be able to do it.
A lot of the letters we do get are about landscaping, where they're supposed to be doing it every week and they're only doing it once a month or once every 3 weeks. But that's most of the letters, Alan, that we get are about landscape.
Well, and that is a major issue, especially in Florida, where, believe it or not, it rains occasionally and the landscaper is not going to come out. And if they've got a schedule that doesn't allow them to come back out, yeah, it's entirely feasible that they may not. But that is an issue between the association and the landscaper, not necessarily an issue between the owners and the association. That doesn't mean you shouldn't send your letter saying, hey, I noticed that the landscaper hasn't been here for 3 weeks. Aren't they supposed to be coming more frequently? But it doesn't mean, and the statutes are very clear, that an owner doesn't have the ability to reach out to the landscaper and say, get your butt here, we need this work done, if they're not a director who's been authorized to have that communication. So it's a matter between the association and the landscaper, unless the association is just not doing anything about the fact that the landscaper is not performing. In which case, you still send the letter or the email or whatever it is to the association, not the landscaper.
Okay, here's Candy in Winter Park. Can an association purchase a unit in the condominium that has been foreclosed on?
Yes. Easy answer. What you can't do in a condo is the individual directors, the manager, the officers, they can't buy the property at the foreclosure sale. But the association can buy it at a foreclosure sale. And if it's been foreclosed already, and the association, if it was like, let's say the lender's foreclosure sale, the association can buy the unit. Just understand, it's going to be pretty expensive. You're going to have to pretty much buy it just under fair market value. So unless you have a specific use that you intend that for, or frankly, you're just trying to avoid some investors coming in and buying up all the units in your condo, you might want to think really hard about whether that's the best use of a couple $100,000 worth of association funds versus, okay, well, we wait and see whether the person that buys it from the foreclosing lender actually does the right thing and is a good member of the community, so to speak. But the short answer, yes.
Does that have to be voted on by the board?
I'm sorry, Steve?
Does that have to be voted on by the board?
Oh, absolutely. If the association is buying property, unless it's in the association's own foreclosure case, in which event they've authorized that action by filing the foreclosure case. If it's someone else's, maybe the lender, maybe a second mortgage, maybe a construction lien, whatever else it may be, or at a tax deed sale. If any of those, the board would need to vote, and possibly the members might need to vote, depending on what you intend to do with that property and depending on what your governing documents say. So just understand, it's not just well, we've got the money, let's go out and buy the thing. It's, well, you might want to consult with your attorney as to whether or not you, as a specific community, have the right to buy it in the manner that it's being sold.
We just got a text in somebody who this is a condo association. They have a lot of iguanas. Whose responsibility to get rid of the iguanas? Is that the board, or am I responsible for that?
Pest control is probably the most responsible. I mean, call some local pest control, not a company necessarily, but the government entity that handles those issues.
Okay.
If there's a bunch of iguanas and they're native, unless the association has the capacity to control that, it may not be anyone's responsibility to get rid of them. But they can be problematic. And so if you think that, you want to get rid of the ones at least that are near your particular unit, your parcel lot, whatever it is, I don't have a problem with an individual owner calling that pest control, either a company or whoever, and trying to take care of it. Now, the declaration may specifically say the association or the member is responsible for pest control. And for the most part, that's what we're talking about, because iguanas can be kind of, they're treated in some respects as pests. So it just depends on your declaration. But the easy answer, practically speaking, which I'd much rather give a practical answer than a legal one in this instance, just call the local authorities that handle that stuff and have them, collect and relocate those iguanas.
Al, this is a text that just came in. They want to know, I guess they've got pet laws, and they want to know, are people allowed to have more than one pet?
Depends on your declaration. There's nothing in Florida law that governs that issue. I mean, in some communities, you can have 20 pets. You can have barnyard animals. It just depends on what's in your particular governing documents. My neighbor has a group of chickens. It just depends what. Listen, Steve, I know you're not in Orlando, but that is not an uncommon thing in Oviedo where I live. Having chickens. You go to the Townhouse restaurant, which is my favorite in Oviedo, and there are chickens that literally live outside the restaurant. So it's not as uncommon. I see the laugh, but it's not a crazy thing if you're from around here. But the bottom line is to answer the individual question, just depends what's in your governing documents.
I think Alan's living right next to the Waffle House.
I'd much rather live right next to a Waffle House.
George in Orlando, love your show. Does an association have to carry insurance on the condominium property?
Thanks for that kind comment. Generally, yes, but when you say condominium property, that's really all the associations generally required to insure. There is, I think it's multi-condos only, a self-insurance provision. But generally speaking, the association is required to have adequate insurance. What's adequate for your particular community is something that you and your insurance carrier, for the most part, will need to decide upon. But just understand what you're not responsible for insuring is the units and their contents. So don't look at your declaration. Have your lawyer look at your declaration to determine what should and should not be covered, and to make sure that the insurance policy you're getting covers what you're required to cover and not a whole bunch of other stuff that isn't your responsibility. But the short answer is yes, a condo should have insurance coverage for the common elements. HOA law doesn't specify that. So just to be clear.
We're going to go to take our last commercial. This is the Ask the Expert show. We're here with attorney Alan Swartzide, K. Bender Rimbaum. We're going to take our last break now. We come back. We'll have more of your questions.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rimbaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680. 888-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
We are back. This is the Ask the Expert show. We're with you every Thursday from 5 to about 5:50 every Thursday. And Alan, I'm going to ask you a question I've never asked you before, but we sit here. Yeah, no, this will be easy for you. Okay. We sit here and you educate everybody and answer questions throughout the show, which really makes for a great show. But tell me, what your clients share many things with you. What do your clients most like about K. Bender Rimbaum?
Candidly, I think accessibility is one of the top things that I hear over and over and over in the last few months. The fact that you can call me and I'm not the guy that says, well, we don't have a call scheduled, so I'm not taking your call, even though you're a client. The fact that you can send me an email, and even if I don't have a substantive answer for you by, a week from now, I'm still going to acknowledge your email within the next 24 hours after I get it. You're never going to go more than a day having reached out to me, or at least one business day having reached out to me before I at least acknowledge that I got something from you. And like I said earlier, I'm hearing that a lot of firms are taking 2 to 3 weeks to even acknowledge an email, and then another 3 to 4 weeks to get an answer out. I'm not promising that every question will have an answer the next business day by any means. But I think that people appreciate the fact that we, as a firm, at least will reach back out and say, hey, I got this, I'm on top of it. And I think that I hate to be the warm and fuzzy guy, but I think that gives people confidence that we actually care, which we do. And other attorneys might as well, but they don't show it, at least not the way that we tend to. And then, like you said, the education, I think, is something that sets us apart. There are plenty of attorneys that are doing educational classes. We're not the only ones by any means, but I think we offer more education, more free education, and more accessible education. I talked about all the things that we're teaching this month. That doesn't count the hundreds of classes we've taught in the past that are available on our website. It doesn't count Jeff Rembaum's roundup emails that go out every other week or so. It doesn't count Robert K's legal morsels that go out whenever there's a major issue. I think between the education and the communication, I just don't know of another firm that can even compete with us. And frankly, that's why about 2 years ago, when I was getting ready to make a move, I texted Jeff Rembaum and said, hey, are you ready? Let's do this. Because I knew there was nowhere better for me to go. There's just nowhere better from my perspective in this entire industry throughout the state. I also think it's helpful that we have a large firm, but not, well, I won't name names, but the people that talk about how size matters, not that size. So we've got the support that the clients need. We're not a two-person firm, and that's part of why we're able to say we'll reach back out, because we're not inundated and overwhelmed. We keep on top of everything. So to have all of that in one package, I just don't know of anyone that does it better, to be candid.
Alan, I got to tell you, I go into attorneys' offices for the show all the time. And I got to tell you, many times I'll walk into an office and there's no one even sitting at the front desk. When I go into K. Bender Rimbaum, your office in Pompano, there's 3 women sitting there to greet you. I mean, you guys absolutely walk the walk.
Well, and that's part of our communication style and making sure that people understand we're not inaccessible. And I think that just, again, it just sets us apart. So I appreciate the question. I just think that we do things differently than a lot of other firms. I think, the expertise that we offer is also very different. The longevity of the attorneys that work here show that our partners actually care about their people. I mean, we've got attorneys that have been with the firm. You got Robert that's been around since the firm started. He was one of the founding partners. Michael joined 20 years ago. Jeff joined, I think, 13 years ago. And I'd say at least 3/4 of the roster, so to speak, has been around for more than a decade. It's hard to compete with that. And so we also have that synergy between the attorneys that a lot of other firms don't have. And I may have only joined 2 years ago, but that's after having worked there for 4 years back in 2010. So that synergy is still there because I've known almost everyone at the firm for 15 years. So I can talk for hours about this firm. I love it. And I know that may be extremely cheesy and it doesn't bother me one bit.
Well, you get so many compliments from our viewers and listeners about your knowledge. And boy, that is a supreme compliment. Let me go, Kelly. What if the board is not enforcing the documents? What can the membership do to correct this?
Get them off the board. That's the easiest.
Vote them out.
If people are not willing to do what they are legally obligated to do, which is actually enforce those documents, they shouldn't be on the board because they're not taking their job seriously, regardless of what else they're doing. You can send a demand or something, but frankly, the best way to address that issue is to either send a demand that the association start enforcing its covenants the way it's supposed to, or get on the board and start doing it yourself. And frankly, I prefer the second option because it gives you more control over how and when you enforce. The other thing that should be done, in my opinion, for every community association in Florida is actually having a policy of how you enforce those covenants, when you enforce it, and you automate it through a management firm if you're using one as much as possible so that the board doesn't even have input on this stuff. It just happens automatically. Everything moves forward the way that it's supposed to. Once there's a violation, the manager takes care of the first 2 or 3 notices. If it hasn't been cured by the time those notices expire, it goes over to the attorney, and the attorney takes it from there and does what they need to do. But you don't have the board sitting and meeting and 5 or 6 different times saying, I think we can let it slide this time. You shouldn't be letting anything slide without a demand being sent. If you don't want to enforce the covenants, amend them out of your governing documents. Don't just ignore them.
Alan, I can't thank you enough. I love doing the show with you. You'll be back again next month for the Ask the Expert show. We appreciate all the people who have written in their questions. Again, I'm sorry I couldn't get to them all, but hey, we'll get to them next time. Thanks, Alan.
Thank you, Steve, and thank you, everyone, for listening.
Have a good weekend. That's
you
attorney
too.
Alan Swartzide. Great attorney. Alan will be back again with us next month. We'll be back with you next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.